Hi there, I'm Paul Golden. I developed Registrant Care as a way of caring for registrants. It's as simple as that. The registrants could be nurses, midwives, doctors. I'm particularly focused on healthcare, physios, dentists, and others. But also other professions are registered and have regulatory law issues. That even includes lawyers. So if your trade union hasn't helped you, I'm working in a very similar way where we stand up for both employment rights, regulatory rights, human rights, and a lot of information is in the book Protect Your Practice. It may be reversed. And the book that goes with this is a global birth legal casebook. So that's specialized about maternity things. And as we know in the news, there's cases like the Lucy Letby case that I wrote one book on. And whether you think she's guilty or innocent or something else, the process was very wrong. And she won an employment grievance, which is very unprecedented and unusual. And after that, the doctors targeted her more. So, as I say, you may have your opinions on that case, but the principles are that the accusers must have evidence, not just accusations. And quite often, there's no smoke without fire is still believed. So simply by taking a case, an employer wants to get rid of somebody and they make up some allegations about them. They trawl through the clinical notes and say, oh, you failed this, you failed that, because they raise safety standards or safety issues about perhaps lack of staff, lack of equipment, lack of training and supervision and management, whatever it is, that then after raising those issues, they're targeted. So that's an employment issue. Yeah, you could go to the employment tribunal, very complex process. Sometimes it works. County court's a lot quicker and easier. And you have to defend yourself, perhaps, to the regulator. That's something I specialize in. And sometimes, like a woman came to me, she was a nurse and she'd been accused of being drunk at work because she'd raised safety concerns. And she was accused of being drunk last week. So she couldn't prove that she wasn't drunk last week. She'd broken down with her car. She was a bit of a fluster, got to work and said, oh, the car broke down. I'm sorry I'm late. And they decided to make that as an allegation. They then put that to the regulator, who didn't take it anywhere. But for some time, she's having to rebut these allegations. And instead of being on the defense rebutting things, I think go on the offense and discredit the accusers and discredit the allegations. And one of the things, and this higher case went to the higher courts, we settled out of court. But as soon as we filed the papers with the High Court for a malicious prosecution, now that has to be filed in the higher court, and there are higher fees for putting in the application. And if you were to claim 500,000 or 10,000, you're going to pay a percentage. So obviously 500,000 gets a higher percentage given to the court, and that's after you've won. But at the time of the application, there's a percentage of what you're claiming. So that case was settled, as so many cases are, with the threat of litigation getting mediation. It's not always nice, happy, agreeable mediation. It's the managers are frightened of embarrassment. They start blaming each other. There's whistleblowers in the institution, whether it's a hospital or some other organization. And those whistleblowers might come out and say, here's an email that'll help you. So getting a data subject access request, maybe a freedom of information request, but collecting information, not giving information, that's the strongest thing I could say in all my advice. Only give the information that's of benefit to you. So you collect information, go through that, you've got evidence, email chain, dates, times, places, names, and you put that in your evidence. Now, I'm very familiar with creating papers with the evidence in, so it's very clear for the fact finder. You don't want to be telling a emotional sob story and how good and kind you are. You have to show facts of who, how, why, what, where, and when, basic things, and make it easy for the fact finder. And you present a very powerful argument and put these together as a bundle, a core bundle. Hyperlink, that just means having that blue line in the index that links to the page later down, and with a page number. So there are three things that court require: is make it as a PDF, it's small volume, put page numbers on it, and have it hyperlinked. So I can show you how to do that. I can even do it for you. And once you've got a persuasive argument and you go back to the employer or whoever you're challenging and who's perhaps challenging you, this makes it look credible that you're going to court, you're going to possibly win. And even if you didn't win, the process would cause a massive embarrassment, a loss of face, but also loss of money and staff tied up. So all their resources will be fighting this claim. Sometimes we saw with the post office, they spent hundreds of millions fighting something that they were wrong about. So sometimes there's saving face, protect the reputation of the institution at all costs. And they will do that and they will try to win at all costs. But others will settle quietly, and whether or not you sign a non-disclosure agreement, that doesn't happen so much outside America. I hear of it in America a lot. It can be required and requested, but everything's your choice. Like mediation can be done in private with a confidential agreement, or it can be a public agreement that you're going to share. If the other side agree to that, and if they don't, the threat is you go to court, and then it could be worse for them. So they may well agree to whatever you're asking. Usually in mediation, you have to give something to get something. And you have to consider the three things. What's the best outcome, the realistic outcome, the worst outcome? So the worst outcome would be you lose and you have to pay their costs. So there's ways to mitigate and reduce that. If you have low income, you're on benefit, anything like that, you don't have to pay the court fees and you may still be at risk of paying their costs. But if you can't pay them, of course, you can't pay them. And if you've done everything reasonable and offered mediation throughout the process, in addition to mediation, you offer without prejudice meetings. That means that you can have a meeting where they say, well, we'll give you X amount, and you can't then later use that information in court. It's protected information for the without prejudice meeting. And equally, you can say things like, oh, I might take less if you give me a good reference or something else. And they're things you can negotiate without fear of it being used in court later. Doesn't always work perfectly. So you've got the worst outcome, you might have to pay costs. The realistic one, that's most likely. The best, you can aim for that. So if you're aiming for 50,000, you might actually get 5,000. But if you can up that 5 to even 10 or 15 or 20, you've done very well. Or we might be talking, 500,000 towards 1 million. So you're asking for 1 million, you settle on half. You've done better than walking away, whatever it is. Now, people don't always want money. They want apology. They want to stop it happening to others. They want recognition. They may not get that. What they will get with a financial thing is that the court has drawn attention to it, if it's gone to court, that people have sat up to listen, although they might actually repeat the same thing to you and other people in the future. But at least you stood up and did what you can. Just going to share the screen so you can see the books I've written will save you a lot of time and trouble. They're quite low cost. And let's see, on Amazon Kindle, if you like a more ethical platform, there's Gumroad, which I'll show in a minute. In fact, let's go to Gumroad now. The same book, sometimes a different cover or picture, keeping midwives safe. Main one I suggest that's helpful is protect your practice and keep your clients safe. So I'm selling it there for 25. It can be an ebook on Amazon. You can get it as a paperback as well as an ebook. The Global Birth Legal Casebook is useful for maternity workers, and some of the principles apply to everyone. But particularly in Protect Your Practice, you can also look at keeping midwives safe, law, mediation, although in midwifery, it's often the same legal principles. There's a very famous case in the UK of Lucy Letby. Whether you think she's guilty or not guilty or something else, the process is very flawed. She won an employment grievance against several doctors, very unprecedented. It wasn't a formal one in a court, it was in the human resource, and chief exec of the hospital managed that. And she won that and then became targeted. And that's a very common feature. Now, expert medical witnesses, that's potentially all of us. One truck driver can say what's the reasonable standard of care of another truck driver. He doesn't have to have a PhD in truck driving. So we seem to make this mistake thinking we need PhD people. Everybody can do it. So you can look at writing your own reports and get other people to help you to write reports that will help in your case. So it could be somebody you met on the day, another clinician, you talk to them about the case, they can write a witness statement. But a medical expert one is looking at the reasonable standard of care of what you did and did it meet the guidelines? And if it deviated from the guidelines, were there good reasons? Do you have a rationale for that? And if you can explain it, they should talk to both sides. So if they're instructed by the prosecution, they should talk to the defense. If they fail to do that, there is liability against medical expert witnesses. And the Sally Clark case was a mother of two babies who died from sudden infant death syndrome. She was jailed, she was a lawyer, and the prosecution had a medical expert witness, Professor Roy Meadows, who said that's 1 in 7 million chance of happening in the same family twice. And he was completely wrong. He was not a statistical expert. So statisticians are very useful, and we've noticed that in the Lucy Letby case. But just because somebody's a doctor saying something, the courts will often believe it. So you need somebody on the other side to counterbalance it, and you need to attack the credibility of the other side and what they're saying. So show how it's wrong and show how yours is right. I've written a book on being a medical expert witness. It's useful for everybody, and if you're engaging with medical expert witnesses. Now, my books are a fraction of the price of what you would spend on 1 hour with a lawyer, between £200 and £300 an hour, and the books are 10, 20, £30. Even 25 is about the maximum. So I recommend that. People are welcome to be in contact with me and ask me anything. I will see if I can now close the Zoom session. And yeah, look forward to your questions and emails. So registrantcare@gmail.com. Thank you.